for
Nsem-Pii or Honomore, now Nsem So. It is Utie, now show on my YouTube channel.
Be the first to know Nsem-Pii TV.
I'm going to be about Nsem-Pii TV platform. And so Friday, May 17th, and I report to Mamo about Parliament reconvening almost a Kokushi due to rules and orders of Parliament. The majority leader, Alexander Kwame for your marking, activity for so Speaker of Parliament, Backben, SI, Emma Omo, Eba Betinasi, ABM. I'm making my Casamara from why. Now, I'm going to a lot of issues were on discussion. I report to my Mulutables among them. Ntra minority leader case out to force in ASN Kudia, Canadian Japan, and Triumph Famano. And no Nsem-Pii TV, yes, I footage from the floor of Parliament. Abra, NDC MP Rockson, Nelson, the Fiamepo, Rebecca here, Saba pay at the Asama Supreme Court regarding human rights and sexuality bill, LGBTQ and Nsem. Now, in Ghana, there are 3 arms of government: executive, legislature, and judiciary. Now, according to Constitution, Omunina independent on their own. Until there was separation of powers. Now, Nelson the Fiamepo, you are a lawyer outside legislature. Now, you are digging on the floor of Parliament, and Adwoa Sarfo, and then Ukraino Bonasum, and more tenacity you come. At the end of the Fiamepo year, and say, as someone on the copy Supreme Court, no, or rising on the floor of Parliament, say, okay, so Kazo be one. Now, on not some more, they are court, no, court in yan tenacity decided the full case, and no more remarks, and will make you on the floor of Parliament. Speak of Babi now, Babi, and so much lawyer, but we deep and not someone attaching a sorry MP for Adwoa South. No man who said there be Yannis as some court, you cannot court, you can on the floor of Parliament. Or can ya the family party? I said, that's how just for sorry, I said the family. You are my junior at the bar. Oh, yeah, Quanacra, say, Mammy, law school, now we young for law school. Attaching and your mammy Adwoa Sarfo senior into a casa was Utino, and any damn hole, NDC for no man, almost at all more reactive. And so I just have one triamon, only uncle, we see on Ghana's chamber.
He's supposed to be in the Supreme Court trying to argue the case here. It's unfortunate. Please, I'm on my feet. Counsel, I'm on my feet. Essentially, I'm on my feet. I'm on my feet. Yes. Right, Speaker, you see, all the arguments of my learned friend and also a member of this August House, it was articulated in the Supreme Court. The interpretation of the matters is raised here is the remit of the Supreme Court, not this August House.
So please give me some time. Yes, my daughter, you are limited to make your submissions.
Thank you very much, Mr. Speaker. Mr. Speaker, I rise on the matter that was raised by my honorable colleague on the other side, Honorable Fiamepo. And my senior at the bar, Honorable Atachia, has enumerated a number of reasons. No, my senior is Honorable Atachia. Honorable Fiamepo, who is a junior to me at the bar, but has raised a very important. He himself admits that he is a junior to me at the bar. I am junior to Honorable Atachia, and I don't see why when I say Honorable Fiamepo is junior to me at the bar, you should raise eyebrows. It is a fact. Mr. Speaker, Honorable Atachia has enumerated a number of reasons why this House cannot be held to ransom. Mr. Speaker, this is the House and a Parliament, an arm of government, and we are just separate and distinct under the Constitution. There's clear distinction of separation of powers when it comes to the Constitution that we have now, the 1992 Constitution. This simply means, Mr. Speaker, that Parliament as an arm, a legislative arm, is independent of the judiciary, is independent of the executive. Mr. Speaker, by the mere fact that there's a matter before the Supreme Court or any court of law does not deter this House from considering that matter. Mr. Speaker, that is so clear. Other than that, I wouldn't see why the framers of the Constitution, with the right intention behind separating each arm of government, would put that in the Constitution. It's for a purpose, Mr. Speaker. So the fact that Honorable Nsem-Pii has brought a matter before the court concerning the appointment of ministers which His Excellency has appointed, Mr. Speaker, I would indulge that you would proceed, this House will proceed with the report, because there is no way that the judiciary would be higher than the legislative arm. That same way, the executive is not higher than this House. So let's give each House or each arm of government the leeway and the freedom, Mr. Speaker, to do its business. What he's trying to do is to say that we should not proceed until the matter is heard. Mr. Speaker, I think that we are masters of our own rules and we are independent and we can proceed. Given the fact that it goes to the Supreme Court decides otherwise, Mr. Speaker, we can be here and do otherwise. But to say that we cannot proceed, I find it very, very, I think that it is not within the scope and application of the laws of this House, Mr. Speaker. So I would urge that we should proceed. Your injunction was thrown out. Mr. Honorable Nsem-Pii, your injunction has been thrown out. So there is nothing that is tying the Speaker's hand from proceeding, or this House from proceeding on the matter. If we overstretch this interpretation to mean that once the matter is before the Supreme Court, this House cannot proceed on the matter, that is not it. Mr. Speaker, that cannot be it. So I will support what Honorable Atachia has said. Let's put aside the application that has been made by Honorable Nsem-Pii and proceed with the report of the Appointments Committee so we can approve the ministers that have been appointed by His Excellency the President. I thank you, Mr. Speaker.
Yes, Honorable Dominic Ayine.
Thank you very much. Right Honorable Speaker, thank you very much for the opportunity. Mr. Speaker, the black letter law of the Constitution does not prevent this House from proceeding with its business because a matter is pending in court. The only instance where our standing orders enjoin us not to do anything, conduct any business that will prejudice matters pending before the court is when we are debating. Order 123 enjoins us not to debate matters that are likely to prejudice pending matters in court. But, Mr. Speaker, the fact that the black letter law of the Constitution does not prevent us from proceeding with business does not mean that, based upon the principle of co-equality of the branches of government, the three branches of government are separate but equal. Mr. Speaker, today's business directly relates to a matter that is pending before the Supreme Court of this Republic. And the plaintiff happens to be an honorable member of this House. Mr. Speaker, if we decide today to approve by a resolution of Parliament the President's nomination of the ministers, Mr. Speaker, what we will be doing is that we are going to overreach the court decision. And by overreaching the court decision, we are undermining the judiciary in terms of its ability to render decisions that bind the parties that are before the court. So, Mr. Speaker, I will urge that we suspend this matter pending the outcome of the case because of the principle of co-equality of the branches and the need for us to respect the judiciary in the performance of its functions under the Constitution. I thank you, Mr. Speaker.
Thank you very much, Mr. Speaker. Mr. Speaker, number one, I didn't realize that the Honourable Member, the Fia Mako, happens to be a member of this House. I thought he was legitimately elected and he is here as a matter of right. I didn't know that he just happened to be here by accident. But that you were not listening. That is an attribution that has been made to you. You weren't listening. I am defending you. I thought you came here by right, and you don't happen to be here, as it has been ascribed to you. So let me continue with my argument. You should be praising me for coming to your defense, because I know that you were properly elected and you were sent to this house. Mr. Speaker, so far you have been calling the genius. They have been struggling. I am the senior. I'm the senior. The senior most is on his feet now, so you should be listening to me. Mr. Speaker, we should be. No, Speaker is not a member, yes. Former majority is stated. The Speaker, who is the bigger one, he is there in his seat. He's not part of us. I'm talking about those of us here. I am the big boss here, so you listen to me. Mr. Speaker, we should be very careful. We should be very... You are not even a junior. You keep quiet. Dominic, we have visited this matter. We visited it. We have visited it again today. Resume your seat, Dominic.
Well, you want to settle the issue of seniority at the bar.
If he wants us to settle it today,
may I know your number?
I am number 91. I am number 91.
91.
91. Let's hear him.
What is your number?
Mr. Speaker, I was called to the bar in October 1995. Ask him the year he was called to the bar.
He just asked me. I just told him. I was called to the bar in Michaelmas term 1991.
No, that's in England.
Michaelmas term.
That's in England. That's in England. That's in England. Ghana.
England, they do. You think they do contemporary law? Is that what you are thinking about? They do the common law. Mr. Speaker, 1991, the senior.
1991. Ghana or England?
Mr. Speaker, it gets even more interesting. It gets even more interesting. Maybe the world should know. Mr. Speaker, 1997, I was approached to come to Ghana, Mr. Speaker, to be called to the bar on exemptions. I was exempted, and in the history, Mr. Speaker, in the history of this country, I am the only barrister who has been called to the bar of Ghana, Mr. Speaker, on the basis of clear exemption. Check the documents of the Ghana Legal Council, the Legal Council. I was called to the bar on the basis of exemptions granted me, absolute exemption, absolute exemption. I didn't write one paper. I was called to the bar on complete exemption. It is there. I was 1997. But Mr. Speaker, before that, I was practicing at the bar of England and Wales starting from November 1991. I would have been a QC. I would have been a KC or QC by now, Mr. Speaker. Let the young guys, let them resume their positions, let them resume their seats. Let's continue with this matter.
Honourable members,
so the matter is settled. The matter is settled. Finally.
Just a minute. Yes, Honorable.
Right, Honorable Speaker, you asked me my bar number. My bar number is 81. 81. And it's 91.
81.
On the left side of the Ghana Bar Association, my number is 81. The Honorable K.T. Hammond's number is 91. So they cannot be.
Honorable members, clearly, since the establishment of the Ghana Law School in 1958 and the Bar Association, until you are called to the Ghana Bar, you are not recognized as a professional legal practitioner in Ghana. Before then, when you are called to the bar in UK, you were fully recognized. And the first Ghanaian to be called to the bar was in 1883. That is Ribeiro.
Nsem-Pii TV